Bismillahir Rahmanir Rahim. In the name of Allah, most gracious, ever merciful. Assalamu alaikum. Peace and blessings of Allah be upon you, dear viewers. Welcome to tonight's live online lecture organized by the UK Daleen or Education Department in the Ahmadiyya Muslim Association. As per our tradition, we will start with the recitation of the Holy Quran. If I could please request Labid Ahmed to recite a portion.
Assalamu alaikum. أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم كتب عليكم إذا حضر أحدكم الموت إن ترك خير الوصية للوالدين والأقربين بالمعروف حق على المتقين فمن بدله بعدما سمعه فإنما إثمه على الذين يبدلونه إن الله سميع عليم فمن خاف من موص جنفا أو إثما فأصلح بينهم فلا إثم عليه إن الله غفور رحيم. English translation is as follows. I seek refuge with Allah from Satan the accursed. In the name of Allah, the gracious, ever merciful. It is prescribed for you, when death comes to any of you, if he leave much wealth, that he make a will to parents and near relatives to act with fairness. It is an obligation on those who fear God. And he who alters it after he has heard of it, the sin therefore shall surely lie on those who alter it. Surely Allah is all-hearing, all-knowing. But whoso apprehends from a testator a partiality or a wrong, and makes peace between them, the parties affected, it shall be no sin for him. Surely Allah is most forgiving, merciful.
Tonight we have the pleasure of being joined by Imran Ali Sahib, who serves as president of the Luton branch of the Ahmadiyya Muslim Association. He is also Naib or Vice National Secretary Sami wa Basri, that is the audio and video department. By profession, he is a wills, estate planning and asset protection consultant. Imran Sahib will be talking about the importance of lifetime estate planning. This incorporates many different areas from both an Islamic perspective and from the perspective of British law. It is estimated that more than 2/3 of the adult population in the UK does not even have a basic will. This can lead to many complications at the time of death. Imran Sahib will be emphasizing the importance of planning during one's life to ensure that at the time of one's death, matters relating to the protection of loved ones, property, and savings can be smoothly dealt with. As always, there will be an opportunity for you to ask questions. These will be put to Imran Sahib in the last 15 minutes of the lecture. Please type your questions into the live chat and kindly ensure that they are relevant to tonight's topic. It gives me pleasure to hand over to Imran Sahib to deliver tonight's lecture.
Assalamu alaikum rahmatullahi wa barakatuhu. Ashhadu an la ilaha illallah wahdahu la sharika lahu wa ashhadu anna Muhammadan abduhu wa rasuluh. أما بعد فأعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم. Before I begin, I would like to thank Secretary Talim and his team for organizing such a fantastic series of lectures on different subjects. May Allah bless them for their efforts. Ameen. And I must also say that it will be very difficult for me to maintain the high standard of the many scholars that have preceded me. And in my case, the word lecture needs to be loosely applied. However, I thank Nadeem Rahman Saab, Secretary Talim, for giving me the opportunity to talk about this very important topic, and I will endeavor to give it justice. As Waqar Saab has said in his introduction, the majority of adults in the UK do not even have a basic will. This can lead to many complications at the time of death. In my line of work, I have personally seen the effects of this, whereby loved ones who should have the right to inherit are left destitute because provision for them has not been made. And on the other hand, you have those individuals who think that they should have a right and wrongfully appropriate the rights of the legitimate heirs. So I'm going to start by talking about what happens without one of these. So firstly, as was recited in the first verse, at the beginning, Surah Al-Baqarah, verse 181 to 183 were recited, but I'm going to focus in the first instance on verse 181. Allah has already put an obligation on those of us who are muttaqeen, those who fear Allah. It is prescribed for you when death comes to any one of you, if he leave much wealth, that he make a will to parents and near relatives to act with fairness. It is an obligation on those who fear God. Now, it is very important to note that death could come to us at any point. It's not just in old age. So we have seen many people pass away at a relatively young age. So, in Sahih Bukhari, Book of Messiah, it is narrated by Abdullah bin Umar that Allah's Apostle ﷺ said, "It is not permissible for any Muslim who has something to will to stay for 2 nights without having his last will and testament written and kept ready with him." So we can clearly see now from the Quran and the Hadith that the importance has been placed on Muslims to have a will in place. So this is from the Islamic perspective. So if we go on to look at some of the common misconceptions that people have in this country and what happens if we don't have a will. So the first one is, my spouse inherits everything. Then some people think my kids will inherit everything. And many Muslims in the UK think that Islamic law will apply because we are a Muslim. Let's take these one by one briefly. Won't my spouse get everything? Not necessarily. It depends on various things, on the family structure, on the assets held, the value of those assets. So it's not guaranteed. So if I tell you that the laws of intestacy, which is simply the law of the land if you do not have a will, they say that only the first £270,000 of an individual's estate will go to their surviving spouse on first death. So if you have a vast estate, then at the first instance, only £270,000 will go. So the remainder is split up into various pots, and some go to the children direct, and some go in life interest to the spouse. But the important thing is that misconception that the spouse will get everything is not true. Let's move on. Pass down the generations. That's what happens in the storybooks. However, more and more families are losing out. And the reasons they lose out are blended families. So in simple terms, if you get divorced, let's say, or if you are a widow and you have some children of your own, and then you get remarried, and the person you marry has children of theirs. So that's what I mean by blended family. That's a common term which is used here. So in that scenario, very simply, if you don't have a will, then there's a strong potential that your children might not get what they deserve and what is fair for them. Because what happens is, like we had said before, your surviving spouse gets a certain amount, a certain portion. Once they have got it, then if they don't have a will, they can do what they want with that money. And your children may well lose out. The second common loss to people's estates is local authority care fees. Now, there are various rules around this, and I'm not going to go into detail on those. However, suffice to say that we have paid into the system. We pay our taxes, we pay national insurance, we pay VAT when we go and buy something. And that's all on the same pot of money. And unfortunately, the care system, when it was set up, when the NHS was set up, at the point of use, everything should have been free because we had paid into it. However, with the aging population, it is getting more and more difficult for that money to be used. So the money we are putting in now is being used for the elderly who are there now. And so when it comes to our turn, potentially the money will not be there. So therefore, that's another thing which is difficult. And then inheritance tax. So again, similar to what I was saying earlier, there are many different rules around this. The basic rule is, if you leave more than £325,000, then potentially anything above that will be taxed at 40%, 40. So in the example I was talking about earlier, you've paid tax, let's say you earn £1, and you're a basic rate taxpayer, let's say about 30 pence in that pound goes to taxes and national insurance. This is a very simplistic example, but it gives you an understanding of what's going on. Then, when you go to the shops, you buy something, you pay 20% VAT. So all of these are legitimate taxes. I'm not saying that we should avoid any of these taxes. These are legitimate taxes. I'm giving you an example of what practically happens. That pound, when you receive it, is 70p. You go to the shops, you pay 20% VAT, that is now 56p. So you save that, you invest it, you buy a property, and you want that to go to your children, your family, your loved ones. However, at that point, with inheritance tax, depending on the situation and what you leave, potentially 40% could go. So that £1 that you earned, potentially 33 pence of it will only go to your loved ones. And that's what happens, it's practical. So the next thing is English law or UK law does not recognize Islamic Sharia law. Now that is a given. So your verbal wishes will not be fulfilled. Your loved ones could miss out on their fair share. So let's talk about what fair share means in this case. In the Holy Quran, chapter 4, verses 12 and 13, Allah gives us a detailed explanation in what fair share is. So I'm not going to go through this in too much detail in this talk today, in terms of what the share is, who gets what. But let's talk about what fair share is and who that should go to as a principle rather than the specifics. It is noted in these verses that the prescribed suitable shares for all near relatives in the property of a deceased person without distinction of sex or order of birth. So there are 4 classes of relatives that are the principal heirs who, if alive, get suitable shares in all circumstances. Other relations having a title only in special cases, so only when the 4 main principal heirs are not there. So who are these 4 principal main heirs? So Allah tells us that our children, our parents, and husbands and wives. So obviously, if a husband passes away, then it's wife, and vice versa. So these are clear guidelines that we can follow when making a will. However, it is also very important to note that if something is given to your relatives during life, it is important to make sure this does not affect the distribution on death. So Hazrat Mirza Masroor Ahmad, Khalifatul Masih V, Ayyadullah Ta'ala bin Nasr Aziz, gave an example of this in his sermon on the 15th of February 2019. And I'm going to show you a short clip to explain this further. So you're going to need to tell me if you can hear this.
Yes.
तो मुस्लिम मौद ने इसमें फरमाया कि हमें इसके मुतालिक कुरान करीम का हुक्म देखना पड़ेगा जो उसने जायदाद की तकसीम के मुतालिक दिया है। कुरान करीम ने इस किस्म के हिबा को बयान नहीं किया बल्कि विरसा को बयान किया है जिसमें सब मुस्तहिकीन के हकूक़ की तयीन कर दी गई है और फिर मुकदमे चलते हैं, संजिशें पैदा होती हैं और फिर आप फरमाते हैं कि कुरान करीम के मुकर्रर करदा हिस्से को बदला नहीं जा सकता। अब देखना यह है कि इन अहकाम के मुकर्रर करने में क्या हिकमत है, विरासत की रूह से क्यों सब लड़कों को बराबर मिलना चाहिए और एक लड़के की शिकायत पर क्यों रसूलुल्लाह सल्लल्लाहु अलैहि वसल्लम ने उसके बाप को इरशाद फरमाया कि या तो तुम उसको भी घोड़ा ले दो या फिर दूसरे से भी ले दो। इसमें हिकमत यह है कि जिस तरह औलाद पर वालिदैन की इताअत फर्ज है उसी तरह वालिदैन के लिए भी औलाद से मुसावियाना सलूक और यकसा मोहब्बत करना फ़र्ज है। लेकिन अगर वालिदैन इसकी खिलाफ वर्जी करते हुए जंबादारी से काम लेते हैं, एक तरफ झुकाव हो जाता है, लड़के हैं, और उसने सबसे बड़े लड़के को एमए की तालीम दिला दी और दूसरी छोटी जमातों में पढ़ रहे थे कि उसकी नौकरी हट गई या आमद कम हो गई और छोटे बच्चों की तालीम रुक गई। अब ये एतराज़ नहीं हो सकता कि उसने बड़े लड़के से इम्तियाज करवा रखा है, बल्कि ये तो इत्तफाकी बात है कि उसकी तो कोशिश थी कि मैं पहले बड़े लड़के को पढ़ाता हूँ, फिर दूसरों को बारी बारी एमए तक पढ़ाऊँगा या जहाँ तक पढ़ सकते हैं पढ़ाऊँगा। यानी वक्ती ज़रूरियात के मतहत उसने जिम्मेदारी को तकसीम किया। नीयत नेक थी, इस वक्त ये काम कर लेता हूँ, जब दूसरे का वक्त आएगा तो वो कर लूँगा। मगर फिर हालात बदल गए और वो अपनी ख्वाहिशात पूरी ना कर सका। लेकिन इसके बरक्स अगर एक वालिद अपने बड़े लड़के को जो आयालदार हो गया हो 2000 रुपया देकर अलग कर दे कि तुम तजारत करो, मगर जब दूसरे लड़के भी साहिब औलाद हो जाएं तो उन्हें कुछ ना दे तो ये नाजायज़ है और इम्तियाजी सलूक होगा। बहरहाल हिबा के बारे में, ये ख़ास जायदाद के बारे में, ये फिकी मसला है जिसे हर एक को अपने सामने जायदाद की तकसीम के वक्त या हिबा करते वक्त, तकसीद करते वक्त रखना चाहिए।
Okay, so we've seen from what Hazuri Akbar Sayyidullah Ta'ala bin Aziz has said there that it's fine to give inheritance or give something in life to other people. However, you have to be very mindful on being fair. Islam is a fair religion, and everybody has a right, their own right. Different people have different rights, but they all have rights. And that's where the fairness comes from it. So in this case, the thing should be very importantly thought about, what you are doing, what you are giving. Now, the other question arises is how much of your estate can you will to charity or those who are outside your principal heirs? So if we go on to the next slide, and in Sahih Bukhari, it is narrated by Sa'd bin Abi Waqas that I was stricken by an ailment that led to me to the verge of death. The Prophet ﷺ came to pay me a visit, and I said, "O Allah's Apostle, I have much property and no heir except my single daughter. Shall I give 2/3 of my property in charity?" He said, "No." I said, "Half of it?" He said, "No." I said 1/3 of it. Prophet ﷺ said, you may do so. Though 1/3 is also too much, for it is better for you to leave your offspring wealthy than to leave them poor, asking others for help. And whatever you spend for Allah's sake, you will be rewarded for it, even for a morsel of food which you may put in the mouth of your wife. Let us return back to what I was discussing earlier about what happens if you don't have and not made a will before you pass away. So this is a cartoon, it's a joke. However, this is what is happening every day. You're on the edge of a cliff, the car is falling down, and the wife says to the husband, now you tell me we've not made a will. So these are the issues and things that could happen if you don't have a will. You could lose your home. You could lose your savings. Or worse still, both of those. So there are many concerns that people have, like we've discussed before. And we need to look at these concerns, what these concerns are. So the first concerns, and these are the reasons why people lose out. First of all, claims against the estate. So this is where there is law of the land, law of intestacy, and there are different rules on who potentially can claim or who potentially could inherit. In your will, if you have a will, you will put in there what is the share that you want to leave. Now, some people may not like that. They will go to the court and say, we deserve this much, we deserve that much. So that's what a claim is. Remarriage of the surviving spouse, revoking any earlier will. So I mentioned this earlier on, but one of the laws that are there is even if you have a will, but you marry again. So let's say you pass away, your wife passes away, leaves you everything, you've got a will in place, okay, which is giving the information and giving the inheritance as per the wishes of the person who passed away, as well as what you had put together. However, when you remarry, that is revoked. And so you have to make a new will. Inheritance tax, so I touched on that earlier on, but that is another concern. And then care fees, we touched on that as well. Now, in terms of care fees, if you think about it, how many homes do you think are sold every year to fund excessive care fee charges? So we've already said that we have paid our taxes during our life. However, because of the lack of money and the planning that the state has, they sometimes force us to pay for some of this care. So last year alone, over 200,000 homes was forcibly sold to pay for this care. And this is rising on a yearly basis. And that is a big concern. So let's recap once again on why we need a will. To protect your assets, to make arrangements for loved ones, to appoint guardians for your children, to make funeral plans, donate to causes you care about, for example, the Jama'at. Wasiyat, ensuring Hissa Jadad is fulfilled. So this is a very important, the last two are very important for us as members of the Jama'at. We would like at some point to leave money to the Jama'at, and if we are a Musi, we want to ensure that our Hissa Jadad is fulfilled. So that the one very important thing to note at this point is the wasiyat we make is not legally binding in this country. There are many reasons for that, which I won't go into just now, but suffice to say, it's not legally binding. So if you want to ensure that you fulfill your wasiyat and pay the Hissa Jadad that you have willed, then you must put that into a legacy in your will. And then it is incumbent on your executors to fulfill that before the residue of your estate goes to your beneficiaries. This is very important. Now, referring back to the hadith, which spoke about the Islamic injunction to give a maximum of a third of your estate away to charity or to non-principal heirs. If you look at the will, the book, the will, and the wasiyat, the institution of wasiyat, look at the beauty of how the promised Messiah alayhi salam has put a limit on the rate of Hissa Ahmad and Hissa Jadad for Musis. So, you know, we don't link these things together if we are not aware. So the regular rate is 1/10. However, the maximum rate is 1/3. And this relates to the Islamic injunction, which is there. Let's move on to the main concerns which I have highlighted. Firstly, how can I prevent the loss of my home and savings? Secondly, how can I protect my young children? And then finally, how do I keep myself safe if everything or if anything happens to me whilst I'm alive? So I'm going to take these one by one and give you some examples of how these can be safeguarded. There are many different ways, but I'm just going to give you some examples of how these potentially could be safeguarded. So the first one, protective trusts. These can be used to safeguard your estate. They can protect against loss to marriage breakdown, care fees, and more. They can protect against probate costs. Probate is the process by which your executors are legally responsible to evaluate your estate and go to the probate court to make sure that they are aware of what the person who passed away has left, and then they stamp a certificate to be able to allow the executors to distribute the estate as per the wishes of the testator, the person who's made the will. These can be prohibitive costs. So protective trust is one way to safeguard all of this. We move on to guardianship. So I've mentioned that before, but the rules around guardianship say that if your child is under the age of 18 and both of the parents who have parental responsibility pass away, then the state want to safeguard that individual, that child. And unfortunately, the way the system works here, it's not easy to make sure that the right people would be taking care of these children. And this is very, very distressful for the people who are left after, you know, the parents. If you imagine both parents have passed away, the children are under the age of 18, they just want to be looked after. They are grieving at that point. So if you've got a will, you can appoint the guardians that you trust. And it's an insurance policy. We all hope and we all pray that we don't die when our children are young. And we pray when Allah, when the time is right, but we pray that that time is not when our children are young. So within your will, if you have appointed guardians, then there is no issues with the state. They don't take those children into care until a guardian is appointed. And as I've said, this applies to everybody with children under the age of 18. So many people out there think, we don't have much. We don't have a big estate. So we've got no reason to make a will. We don't need to make one. Your children are your biggest asset. You want to safeguard them. You need to safeguard them. It's very important. So as I said, without the will, the law decides who the children would go to. And in some cases, it could be a stranger. If the courts look at it and they don't think from their point of view, they can find a suitable person, because you have to go to the court and apply to be the legal guardian if it's not in the will. So it could be, the child could be fostered out, given up for adoption. That's not what you may want. So it's very important. Thirdly, lasting power of attorney. So will is very, very important, as we said, to put your will, your wishes on when you pass away. However, when you have passed away, you're not going to be there to make sure that those things have happened. You won't be able to know what's going on. However, when you're alive, it's also important to put your affairs in order and put an insurance policy in place. A lasting power of attorney protects you whilst you're alive. As I say, it's just as important as a will, and it's the best way to ensure your loved ones take over smoothly should anything happen to you. Nobody knows what's around the corner. It's a safety net, just in case. So in simple terms, if you lose capacity and you haven't put something legally in place, then the court of protection has to be applied to individuals. So your bank accounts could be frozen. Other things could be frozen. Your loved ones might not be able to pay your bills. So they have to apply to the court of protection. That is a very long and prohibitive, restrictive process. You cannot spend more than £5,000 of your own money without their authority. You have to do a statement of accounts of your own money to account for every penny that has been spent. All of this can be avoided if you have appointed attorneys who you trust before you lose capacity. So in conclusion, good lifetime planning and the right will can protect your home, protect your savings, protect vulnerable loved ones whilst you're alive, and help ensure maximum protection when you pass away. So this, in a nutshell, is the importance of good lifetime planning and estate planning. Now, I don't have the time to go in detail in many different areas. Maybe sometime in the future we can do that. But I hope that all of what I have told you today wakes you up, makes you think Have I got a will? If not, should I have a will? Why have I not thought about making a will at the moment? The heartache, as I said earlier, that loved ones go through if people's wishes are not put forward and the laws of intestacy are put forward. Sometimes, it makes me emotional because I have seen it at first hand. So, finally, Jazakallah for listening. I hope it has been productive and informative. So, Bakar Sahib, I'll hand it back to you.
Jazakallah, Imran Sahib, for a very detailed presentation. We have a few questions which I'll put to you now. The first question is from Ramin Masood Sahiba. She asks, wills can be as comprehensive as we want. So what are the main points that we should definitely include in a will?
That's a very good question. So right at the beginning, right at the top, we've said that more than 2/3 of the adult population potentially don't even have a basic will. So the basic will contains 3 or 4 things which I would say is very important. The first thing is you would say who your executors are. So you can choose the people that you trust who will administer your estate to make sure that your wishes are fulfilled. Secondly, as we said, if you have children under the age of 18, it's very, very important that you make sure that they have been, or the legal guardians that you want are there, have been mentioned in that. So that's 2 things. These are all your wishes, because if you don't have any one of these that I will be mentioning, the will potentially could fail. And even if you have tried to make a will and gone to that effort, it would go back to the decisions that the state makes. So executors, number 1, legal guardians, number 2. Number 3, especially if you want to leave something to anybody but your beneficiaries in terms of your family, which is very important to write a legacy. So legacies are fixed amounts of money that would go to either an individual or an organization, like a charity. For example, the Mosque Fund or something of that sort. And one thing that people don't think about, and they think, oh, look, legacies, we don't need to leave a legacy. Like Hazur Akhtar Sayyidullah Ta'ala bin Nasr Aziz said in the clip that I played you, that during life, you may have given something to one of your heirs, one of your children, over someone else. Let's say one of your children is old enough to buy their own property, so you may have given them some money as a deposit. So in that case, if you don't at that point have enough money to give to the other children, it's very, very important to put that in a legacy. Otherwise, when the residue of your estate, the remaining amount, is distributed amongst your children, that child that has already received some money for you as a deposit would get more than the rest of them. So that's a legacy. Thirdly, in terms of the residue of your estate, it's important that you put down, especially in this country, as I said earlier, that Sharia law does not apply. So if you want to be fair to your beneficiaries, fair to the people that you are leaving behind, and you want to leave the fixed amounts as per verses 12 and 13 of Surah chapter 4, Surah Nisa, it must be there in the residue. You must write in there what those shares are. It all depends on who is left, who is there, but this is important. And then finally, your funeral directions are very important as well, because your loved ones, they know what you want. If you're a Musi, you will be buried in the Vishnu Bakbara or the Musi area of the graveyards. If your choice is you want to go to Rabwa or you want to be buried in Rabwa, then that's your choice. And your loved ones may well know that. The will can be picked up by anybody at that time. Let's say, God forbid, your whole family is together in a car. And God forbid you have an accident and you all go. That will can be picked up by any solicitor in the UK. The state will appoint an administrator at that point if the executors are not there. They will go through that. If you haven't written down what your wish is, because I know it is very difficult. We don't talk about these things. We don't talk about death. We don't talk about where we want to be buried. So at that point, they can pick it up and they say, oh, look, this gentleman wanted to be buried in this place called Rabwa. They will inquire and make sure that is done. So these are the 5 main things that should be in any basic will.
Jazakumullah. Next question is from Malik Faraz Ahmed Sahib, who asks, are there any compulsory or significant costs which are attached to will planning and writing which should be borne in mind?
That's a very good question. So, like anything, it's important to go to a professional. So, let me give you an example. Let's say you've got a toothache and you go online and you have a look at it and say, you Google it, doctor.com or something like that, dentist.com if there's one, and it says, you put your symptoms in and it says, take this medicine or take a paracetamol and whatever. However, going to a professional, paying that money, that will ensure that those problems that you have are correctly looked at. Same with a will. You can go to W.H. Smith, for argument's sake, pick up a will kit for $9.95. You'll put in there some of the wishes. There's a template. You put those wishes in. However, there could be many things which are missing from there. There could be many things that you don't know because you don't know the way the law works. So I always recommend, if you are going to a professional, like a Corgi registered gas specialist, for when you're putting your gas oven in, he will make sure that all the connections are tight and everything is fine. There's no gas leak. You can do that by yourself, but God forbid, after a few days, there might be a gas leak and the whole place could blow up. Similarly, go to a professional solicitor, will writer, whoever you feel is important or available at that time, and they will do it. Now, let me give you an example. It's not prohibitive. A basic will can start with a professional from £95 plus VAT. And for that amount, you can save all that heartache. Yes, as she said, there might be various different structures and many different things that might have to be done with more complex estates. And obviously they will cost accordingly. But as I say, you can get professionally written will for less than £95 plus VAT, or for that amount.
Jazakumullah. There's a question from Alicia Ahmed, specific to disability. And her question is, what kind of will should be made for disabled people?
That's a very, very good question. And we see this very often, that people who potentially cannot inherit outright. So a basic will, in simple terms, says that at the time of my passing, my executors will administer it and they will give outright the shares that I have stated as my wishes. And that goes outright. What does outright mean? That means the executors are responsible to put that money in that person's bank, and that's it. They walk away. Now, as the lady said, people who potentially are disabled, different variety of disabilities that people have. Some disabilities mean that you are unable to do things for yourself. And if you got a pot of money, there will be two things that potentially could happen. Number one, you will not be able to deal with that. People who are around you may well take that money from you. Secondly, especially at the moment, some of these disabled people, they are getting allowances from the local authority. And it's very important that they get that, because they are not able to earn a living sometimes. And so therefore, the state is there to assist them. However, if suddenly they get a £200,000 inheritance, at that point, potentially, until that money is used up for their care, that those allowances may stop. So in those cases, there are things that we can put in place. We can add into the will that will trigger on death, and they are called trusts. Trusts are simply legal entities for which you have set the articles of association, you have put down the rules of that trust, and you potentially have appointed trustees. So in the case of a disabled child, you could potentially appoint trustees who are other siblings who are well. So their role is to make sure that that money which has been given to that disabled child, which is in this protective trust, in this protective legal entity, and now they can give it to those or use those funds for those disabled children or disabled child or disabled adult, whoever it is. It doesn't have to be a child, it can be an adult. This way, it safeguards their inheritance. And secondly, it will allow those trustees to make sure that they are using those funds in the correct manner for that individual. I know this is very simple, and in this time I can't give you a detailed answer, but I think that suffices for now.
Zaka, Imran, so the next question is from Nair Ali Sahib, who asks, if you are a Musi and also have a separate will, and after one's death there is a conflict between the two, what should the family do in that situation?
That's a very interesting question, actually. I think that's why it's so important that Musis have done at least the basic will. And to be honest, at the moment, Marcus has asked for some clarification, and I'm talking to Naib Amir Saab and Secretary Wasaya, and we are looking at trying to come up with a plan by which every Musi in the UK needs or is encouraged to do a basic will, at least. That's because, as Nair Saab says, there is potential that as a Musi, you're saying, I want to give 10% of my estate to the Jama'at as his jadad. However, in your will, you have not left any provision in there. In your will, you have said, the residue of my estate will go to my beneficiaries, who are your children, for example, your loved ones, your parents, your spouses. And these things sometimes can cause a lot of problems. Now, people who have taqwa, children who have been brought up with the beard, they will say, okay, look, my father or my mother or whoever had done a wasiyat. And 10% or whatever the share that they have said needs to go to the Jama'at. And they will ensure that that is done. However, Mayor Sahib is absolutely correct. There are some people who, once they see money, they think that's our money. And my father or whoever may have done wasiyat, but that's him. Good luck to that. I have been given this money. There's no reason for me to give it away. So what I would recommend, all Musis, they specifically should make sure that they have put their wishes down in at least a basic will to say that that portion of the Hissa Jadad should be given before the residue of the estate goes to their loved ones or whoever their beneficiaries may well be.
So, these will be the last two questions, which I'll pair together, although they are of a different nature, just for the last couple of minutes of tonight's session. One question from Majid Ahmed, who says or asks, if you have investments in financial securities or assets, how are these treated in the context of a will? And are there any special arrangements that need to take place? And also one final question from Ramin Sahiba, who asks, in the will, can parents nominate their eldest child when they turn 18 as a guardian for younger siblings?
Okay, thank you very much. I'll take Ramin Sahiba's question first, just because it's very straightforward. Yes, anybody over the age of 18 can be appointed as a legal guardian. So often, when I go and do a consultation for people and they have older siblings, I often guide them that these are good people to be appointed as legal guardians. Coming back to the previous question about investments. So the way on death it works, your executors are responsible to make sure that all of your assets are evaluated. So they are legally responsible to make sure that they write off to the registrars in terms of shares, investment houses, to the banks, pension people, and everybody like that. And once they've done that, that comes back to them. That then goes to the probate court. So there's various classes of assets that cannot be released without that probate certificate. Some classes can be just with the death certificate. You go to the bank if you've got less than £10,000 in the bank, and the next of kin, for example, the wife, can take that and say, my husband's passed away, and they'll transfer those funds into their account. However, there are many different assets, like investments, most investments, that cannot be withdrawn without that probate certificate. So that's the first thing which is important. Secondly, if we are looking at complex estate planning and we are looking at more than a basic will, then we may well incorporate some of these investments into trusts. And when we put them in the trusts, they then would automatically go to the secondary beneficiaries, the people who we've nominated, and they don't need to go to some of these probate processes. But it all very much depends on the type of investment, the class, the type of assets that we hold. So it's quite a detailed question or answer, which may well need to be made, but that's just the general part of it. What was the second bit, Muqasab, or is that it?
I think you've covered it quite comprehensively there, Imran Sahib. Jazakallah for obviously responding to everyone's questions and also for the very detailed presentation tonight, which I'm sure everyone's benefited greatly from your professional advice and guidance. So Allah bless you for your time this evening. Our thanks also to our viewers for tuning in as always. Our lectures return next Monday, 27th of July, when we'll be joined by Mubarak Ahmed Siddiqui Sahib, who will be speaking on the topic of the poetry of the promised Messiah alayhi salam. That lecture will be done. And then a week today, on Tuesday, we'll be having an English lecture by the head of the Jama'at's Central French Desk, Abdul Ghani Jahangir Khan Sahib, who will be speaking on the topic of who was Adam. So please make sure that you join us for both of those lectures next week at the same time at 7:30 p.m. I will now request our respected National Secretary Talim, Nadeem Rahman Sahib, to offer any closing remarks.
Jazakallah, and as per usual, I would like to convey my thanks to Imran Saad for taking his time and coming, and also to our viewers. And if you could all join me in silent prayer so we can conclude the session. Please join me in silent prayer. Ameen, summa ameen.
Wa alaikum
Jazakallah,
assalam.
assalamu alaikum wa rahmatullahi wa barakatuh.